SJC-11397, Fitchburg Gas and Electric Light Company, et al., v. Department of Public Utilities.
Let's proceed. Good morning.
Good morning, Mr. Chief Justice. May it please the Court, David Rosenzweig appearing on behalf of each of the electric companies operating in the Commonwealth. This case concerns a statute passed a year ago by the legislature, Chapter 216 of the Acts of 2012, and a related order of the Department of Public Utilities that impose a statutory assessment on the entire electric industry each year and that permanently deprives the electric companies from an opportunity to recover that assessment in future rates.
But may I ask you, I assume there's a statute which says that you're entitled to a fair and reasonable return on costs. Am I correct?
Your Honor, it's more a matter of case law than, from the U.S. Supreme Court and this Court that do express the constitutional view that electric companies under cost of service rate-making methodology have a reasonable opportunity to recover their prudently incurred costs plus a fair return.
Okay. Let's assume there was a statute passed which says that you're entitled to a fraction less than your fair and reasonable return. Would that be a constitutional taking?
In terms of the department rate-setting process, we aren't challenging any rate-setting. The department has performed setting new rates. We're challenging the statute directly.
Right, and assume there was a statute passed which says that customarily you're entitled to a fair and reasonable return. We're going to change that, and we're going to give you a very small fraction less than a fair and reasonable return. Would that statute be on its face unconstitutional as a taking?
It would, Your Honor. Under Article 10, it is not the size of the taking. It's the taking without just compensation that offends the Constitution. And so if you set a reasonable return for the companies and then say by statute you're going to get something less, there is some element of a taking of their property, and their money is property for purposes of Article 10.
But if it was real property and there was an imposition of zoning or whatever else which would diminish the fair and reasonable return on that real property investment, that would not be a taking.
It would, Your Honor. If, for instance, let's say there was a taking of a person's property, maybe a 1 foot square of property. That
I'm referring to, say, a zoning imposition, a regulatory zoning, which the person expected that they get a 12% return on that real property, and instead, because of the zoning imposition, they're going to have additional costs. It's going to be 11.9%.
I think that one of the material differences, Your Honor, is that we're in a regulated industry. This is not a situation where a person has a choice as whether they're going to participate in an industry or be able to pass through costs to future customers. We have only our statutorily and regulatorily set rates by the department, and we commit our capital to serving customers and providing them least cost service, and we have an obligation to serve. The only way for these companies to recover their money is when that money is fairly reviewed by the department in a rate setting process and they're able to recover their prudently incurred costs.
So does that mean that every time there is a dispute as to whether a cost is reasonably incurred, it's a constitutional taking issue?
It may not be a constitutional issue. As the Attorney General cited, sometimes there are confiscation cases where electric companies or gas companies might challenge the overall rate. But more often, the instance might be if there was a department rate-setting process, it might be a question of substantial evidence or subsidiary findings to justify the department disallowing a cost that was mandated by the government. There'd be no question about its prudence or some cost being incurred in bad faith. There would have to be some evidentiary basis and subsidiary findings to support the disallowance of that cost, or it would be an arbitrary and capricious denial of the cost being reflected in the cost of service rates.
If in these cases, and I'm sort of relying on a little history here, if this were included in the rate-setting process, this amount of money were included in the rate-setting process, but it was factually determined that the electric utility companies really did not act appropriately during a particular storm, And so a portion of this amount was disallowed just because of inappropriate, or an inappropriate response by a particular company. Would that offend the Constitution?
It would not on its face, Your Honor, and there is a process in this same statute that allows the department to conduct annual reviews of the company's storm performance, their emergency response plans, and if they find that the company has acted unreasonably with respect to some aspect of its storm operations or its responsiveness to major emergency events, the department has been delegated authority to impose penalties based on those findings of imprudence. But this assessment itself is separate from that, and I think it's important not to conflate the assessment and the non-recoverability of the assessment from a due process issue where later the department makes a determination on a particular record that certain actions by the utility were unreasonable.
Why isn't your action, the lawsuit, why isn't it premature? Why shouldn't we wait to see how the agency is actually going to interpret this statute, to see if it's going to, in fact, give you your day in court on this particular issue?
The Attorney General's made the same claim, but we believe the claim is ripe. We're challenging the statute on its face, and the application of that statute now by the department has been made clear by 2 orders where they have imposed an annual assessment on the electric companies, and they have parroted the language in the notwithstanding sentence in the statute that prohibits the recovery of these costs permanently, in perpetuity, under all circumstances. So there is no reason to await for a further determination. In fact, if we were to await for a future case, the electric companies could easily find themselves in a catch-22, where the claim could be made that they should have appealed the department's orders denying them the cost recovery at the outset within Chapter 25, Section 5, which is a 20-day review time frame, as opposed to waiting 3 years from now when some other future case in which their base rates were determined and the result of their disallowance was become known. There is no question on this record that the department at this point would not allow recovery of these costs. There's been 2 orders from the department that have set that forth. The statute itself makes that plain as day. And so there's no reason to wait for a future determination in order to present the claim to the court. The matter is ripe. There's no question. It's apparent on the face of the statute. It's apparent on 2 department orders. And so the issue is now ripe for the court's determination.
Is there any other situation in which the department or by statute has said that certain costs are not recoverable?
They have, Your Honor, where there has been a finding that the company has acted in bad faith or spent excessively or imprudent in some manner, but not with regard to these types of assessments. We cite in our brief 6 examples of statutory assessments that either explicitly or in practice
Can be recovered.
allow for the recovery of costs in future department proceedings. And the department doesn't contest that.
There's no counterpart to this in the rest of the regulatory
There is
assessment
not,
scheme.
Your Honor, and the department doesn't claim, and I think it's notable, that if these costs were eligible for recovery, that is, there was not a notwithstanding sentence in the sentence, in the statute, that they would normally be recoverable in a future department proceeding. It's purely the notwithstanding sentence, which is a permanent absolute bar in perpetuity against all the electric companies, regardless of fault, regardless of any actions on any particular storm in any future year, that they will be not allowed to recover these costs in future rates. And we believe that runs afoul of Article 10 of the state's Declaration of Rights, which make clear that when the government appropriates private property for public use, and here the property is the monetary property of the electric companies, there needs to be reasonable compensation therefore. And here, under the statute and under the notwithstanding sentence, there's absolutely no compensation whatsoever for the costs that are incurred in paying the statutory assessment. And it's not a de minimis amount. If you look back to the 1982 Boston Gas case, there a one-time $50,000 assessment was imposed on Boston Gas for it to conduct a management audit. And the court found in that case that that was the monetary property of Boston Gas and that it was not de minimis in terms of an Article 10 analysis for purposes of a Declaration of Rights determination.
But it declined to decide the constitutional issue on that point.
It did, Your Honor. It declined to do so because there were some two issues. One, the issue of the takings analysis wasn't directly presented, and there was some underlying question of negligence on the part of Boston Gas in terms of its gas procurement, which is not apparent on this record. The key distinction here is that this statutory assessment is multiples of the one that the department did not find, the court did not find as being de minimis in the 1982 case, and it occurs each and every year in perpetuity. So over a period of years, you might be talking several $1 million that are at issue, and it applies across the industry where there is no a priori finding of negligence or question of negligence on the part of the companies, because this statutory assessment would be disallowed in terms of cost recovery for each of the electric companies for all future storms, even if they've acted perfectly, or there are no storms in any particular year. So there is no conceivable basis to support the imposition of this statutory assessment without the opportunity of any cost recovery.
Is there a legislative history that tells us why they didn't include this in this law?
There is no such legislative history, Your Honor. The department, in its brief, cites to a few newspaper articles and one pending storm investigation the department was conducting with regard to one company in one storm. But that in no way would serve as a justification across the board for all electric companies in all circumstances without regard to their performance on those storms to have a statutory assessment that was not recoverable and with no due process opportunity to show that it was a reasonable cost that warranted inclusion in future rates.
So going back to the beginning here, what is your fundamental right? It's a right to a reasonable rate of return, isn't it? In a regulated industry?
If we had gotten to the department rate-setting process, that would be part of a claim if we were going to challenge the constitutionality. But here, it's a statutory challenge, and we're presenting it under Article 10 of the Declaration of Rights, which requires two things: that there's a taking of the company's or a private party's property, and we have that here, and there is reasonable compensation for that taking. Here we have both the taking and we have absolutely no compensation, and we know that as a matter in perpetuity, that taking will occur every year without any compensation, reasonable or not, for the electric companies.
Essentially, what you're saying is it's not even part of the rate-setting process.
We never get to that point, Your Honor. The department will never have the discretion to determine whether this is an eligible cost for recovery. We do submit it would be if it were presented to them, but that they are divested of that authority by the statute.
Even if you get a reasonable rate of return, the fact that this one item is not a cost that you can recover still is a taking.
It still is a taking because under Article 10, its size is not the question. It is the taking without compensation, and even small takings, if they're total and they're permanent.
Well, but we have small takings all the time. Zoning is a perfect example where the value of property is diminished because the government has put some restrictions on it. But that's not a taking unless you've seriously diminished the value of the property.
But here, for the regulated companies, all they have is their monetary property that they put into service to serve customers.
Yeah, and you're going to get a reasonable rate of return, and if you don't, you can raise holy heck.
Well, two things, Your Honor. First, with regard to the size of the assessment, we now have a Rule 16L letter that was filed just a couple days ago by the department. And they interpret their authority, and we disagree with this, and we ask the court look at it. They now interpret their authority under the statute as not being capped by inflation on a year-to-year basis. They believe they have the authority to set the assessment at any level they deem necessary and appropriate, as long as they certify it, in order to achieve the statutory purpose. And then on top of that, it may increase by up to inflation.
But what's the benchmark? Is there a benchmark for reasonable rate of return in the rate-setting process? Is it 8%?
It depends on the case. It's set individually in individual proceedings by the department, and that may vary from case to case based on the record. But for each of these companies, they have an allowed rate of return, and those rates are set very precisely. They are able to recover or seek recovery in their rates of all the costs that are reasonably incurred and achieve a certain level of return. But when after the fact, after their rates are set, there is a determination that a particular government-mandated cost is being incurred, is not being allowed for recovery, they per se will not be able to achieve their return, and constitutionally, their property has been taken. And so our concern is that there is no reasonable opportunity, which is the constitutional tenet on which rate-making is based under Hope and Bluefield from the U.S. Supreme Court, that when the electric companies or any public utility prudently incurred costs, they have a reasonable opportunity to recover those costs and achieve their return. There is no such opportunity when there is a statutory bar to seeking recovery of the costs.
Now, the AG characterizes this as a regulatory taking. What do you characterize it as?
It's more of a per se taking on the statute. We bring the regulatory
That's
element.
been applied only as to real property, hasn't it? A per se taking?
It is a per se taking of the company's monetary property.
But has that ever been applied to anything other than real property?
Well, in the Boston Gas
In the Boston Gas case, the court was undertaking that analysis, and it stopped short of making the finding because there was some question as to what the parties were alleging in the case in terms of it was a standings law case as opposed to a takings case, but it was the same Article 10 analysis in the 1982 Boston Gas case. And the court went so far as to find that the monetary property that was at issue in that case would be a deprivation of property. And I think under the right record, and it's for the court to determine, if the takings claim was made, the court would not have left the constitutional issue undecided. But they did sever the provision from the statute at issue there that disallowed cost recovery because there was concerns about its legitimacy under Article 10 of the Declaration.
Whatever happened to that? Do we know whatever happened to that? I know it was severed, but whatever happened?
What happened was there was a management audit that was ordered for the companies, and they did conduct the management audit and spent the money for the management audit. Whether that amount was ultimately recoverable in future rate proceedings, I can't say at this.
But there was no further litigation with regard to it?
There was not, Your Honor.
Counsel, your time is up.
Thank you, Your Honor.
May it please the Court, Bruce Cray, Assistant Attorney General for the Department. As Mrs. Rosenweig just said, their main claim is that a per se possessory taking occurred simultaneously with the assessment when the companies were required to depart with their money.
So, Mr., do you say that, I mean, you make the argument that they're they can't squawk until their rate of return becomes confiscatory, basically, right? I mean, or that they can't recover enough costs to do their business.
That's as regards, they do make a separate regulatory taking claim, but our argument on the per se taking claim is much more direct, and it's based on 8 separate circuit courts of appeals. And that is that when you're not talking about land, but instead about a statute that simply requires the payment of money from one's general funds, per se taking, possessory taking does not exist.
But doesn't that depend upon whether or not the taking, it can be examined in the context, a broader context of a rate setting? And here, at least on page 34 of your brief, what sort of jumped out at me was that you said, well, this is premature. What they need to do is go through the rate setting process. Of course, and I think you said this in your brief, something along the lines that they can't make a request for reimbursement or even a partial reimbursement of the assessment, but they need to do this under protest. But what impressed me about the argument was it seems to be an acknowledgement that this assessment is off the table during the rate setting process.
It is off the table.
So how are the rate-setting cases even applicable here, and the reasonable rate of return cases? How are they even applicable? You're requiring them to set up a separate fund outside the rate-setting process.
To pay, not to set up a separate fund, but to pay some of their own monies out of their own general funds that would go to set up a separate fund. In my initial brief, as I had read their brief, they were both attacking the payment and then the lack of recovery. And their main focus in their blue brief was on the lack of being able to recover it. And I had that analysis, Your Honor, just set forth, directly addressing it. In their reply brief, they responded no. As I've read the reply brief, what we're really talking about, our prime claim, is that at the time of the assessment, because you at that time also cannot recover it. Those things occur simultaneously. The assessment and the prohibition on any recovery, that constitutes a per se taking. That was something I addressed in the initial part of the argument in my brief, but I just want to elaborate on it here since it does seem to be their primary claim that there's a per se taking affected because there's a simultaneous taking of money, or excuse me, demand of an assessment of money and a prohibition on recovering it. Yes, Your Honor. So
No, you go ahead.
my first position is that the circuits eight circuits are very clear that simply the payment, a requirement that you pay money out of your general funds is not a taking. It does not rise it. I'd cite the City of Cleveland case, McCarthy, 2010, in my brief, where it states, all circuits that have addressed the issue have uniformly found that a taking does not occur when the statute of question imposes a monetary assessment that does not affect a specific interest in property. It cites 7 other circuit decisions. When you combine the 10th Circuit's own ruling, you get to 8.
And are they all situations like this where there is an assessment that is not recoverable by a regulated industry?
No, and they aren't, Your Honor, but they set forth that as a general rule, and they certainly don't say there's an exception when there's no recovery. It's Mr. Rosenzweig and the companies are claiming that there should be, and there isn't here. The reason for the basic rule that I just read from the Sixth Circuit is that there needs to be a specific interest in property for the property to be taken.
Oh, okay, but your brother is saying, if I read his brief correctly, that the state can, they can require us to pay this money. He's not contesting that you have the ability to order them to pay out of their general funds this money that apparently the 8 circuits agree with. What he's saying is, you can't do it without also giving me the opportunity to try to recoup that money in the rate setting process.
And my response, Your Honor, is that none of those cases make that distinction, and his claim is that there is in his brief, immediate and direct taking as soon as the assessment occurs because of the inability to recover. But there's simply a categorical rule that you're not in takings land when you're talking about a general obligation to pay money, a general liability, regardless.
In those 8 circuit court cases, were the payors at least, was the door open to them to try to recover their money?
It was open, but in at least one of them, it was an individual. They were individuals, and when you're just a person who has a fee assessed on you, ordinarily that comes out of your own funds with no one to pass it on to. I supplied a 16L letter with additional cases where fees or various types of monetary exactions were imposed on individuals, and the same rule was applied to them with no disregard. The reason, I think, is that the reason underlying the rule is that general money is treated as fungible. The Supreme Court said that in the Sperry case. It's fungible, and it said, indeed, it would be an extravagant expansion of its real estate cases to go into, to put per se takings doctrine into this area of obligations to pay money. So you still don't have that specific interest in property, regardless of whether or not you can pass it on.
Well, supposing next year the DPUs or whoever sets this assessment says, we got 3 inches of snow, we're going to assess each company proportionately, you're going to have to come up with $10 million and divvy it up. So the $10 million, they can't get it back through the rate setting commission or through the rate setting process. Is that a taking?
No, well, they could assert a regulatory taking claim at the time of their that they were seeking recovery through rates. They could. The procedure we set out that they could follow, so that because we realize that in that kind of hypothetical, they certainly should have a right to seek to at least have a claim for relief.
But how? In a suit for declaratory judgment?
No, Your Honor. They simply, at the time they file their rates, they make it clear they would be including this specific amount, the $10 million, but for the statutory prohibition, they're excluding it under protest. They're claiming that it constitutes a confiscatory rate. It renders the overall rate confiscatory, and that they should have that challenged.
So this statute would be unconstitutional as to some companies, but not as to others, depending on whether you could prove it provided for a confiscatory rate?
Not the statute, Your Honor. The statute on its face would certainly be if there was an amount assessed that when combined with all the other components in the rate set the entire rate so low as to be confiscatory, then there could be a claim asserted. But here we don't even have any actual rate it's connected
But
with.
that's my point. I mean, I take it that your argument would be, yes, they've done it as an assessment that's pro rata against the companies, but I mean, the same theory would go, just saying each company is supposed to pay $10 million into this fund, storm investigation trust fund.
Yes, Your Honor, and that's, in that hypothetical, Your Honor, there would not be a per se possessory taking
Right.
claim, no funder. There would be a possible regulatory taking claim.
Right.
But it would be subject to some pretty strict rules on that side of the game as well. The general confiscatory rates, the court is, that doctrine has seemed to treat it as a subset of the broader regulatory takings doctrine, which is multi-factor, has a lot of things involved. And some of the rules have evolved. You have to have an actual rate. This has to be, you don't just look at this piecemeal in the abstract in isolation. It has to be part of overall rate. That what matters is what's the overall impact of that rate taken as a whole. And this is quite important, this is also where I differ with Mr. Rosenzweig, that overall impact has to be pretty bad, pretty darn bad. The Supreme Court twice in Duquesne and Verizon categorized the standard as quote-unquote jeopardizing the company's financial integrity. I read this court.
How is that consistent with reasonable rate of return? Where
Your
does
Honor,
reasonable rate of return come in here?
Your Honor, excellent question, and I completely disagree that there is a reasonable rate of return as a constitutional standard. Starting with the Hope Natural Gas case in 1944, at the Supreme Court level, it's quote-unquote fair and reasonable rates, not fair and reasonable return. And that's been elaborated on in subsequent cases, like the Permian Basin case, where the Supreme Court says you can limit stringently returns, because it's not just the investor's interest. The Supreme Court says it's a balancing between the investor's interest and the consumer's interest.
But one of the problems I'm having conceptually is that you seem to be using the de minimis aspect of at least this initial assessment as not interfering or not detracting from a reasonable rate of return. It's only, I forget what it was, 37/10,000ths percent of
0.0037%.
of their profits. But it need not be, and if once it starts edging up, the analysis isn't the reasonable rate of return or the de minimis aspect of it. It becomes more of a confiscatory analysis. And yet you allow them to make the argument in the rate setting process if the amount is absorbent, but not if it's a small amount. Wouldn't you be so much better off just letting them make the claim that we need to recoup some of this money and just blow it off? It is saying, look, it's de minimis. It doesn't make any difference to you.
Your Honor,
You're getting a reasonable rate of return.
Let me clarify my response. I wasn't saying that they couldn't raise the claim in the rate setting context if it were small.
Well, you did on page 34 of your brief. You said that they couldn't ask for it to be included in the calculus. They had to mention it under protest.
Well, that's because the statute. But at the time, they could they could put it before the department. Their claim that it's exclusion, even if mandated by statute, is confiscatory. And either, I understand, the department at times handles such claims of confiscation at the same time that it looks at the overall rate, or even if that weren't the case, this court's very clearly empowered under Chapter 25, Section 5 in its review to do its own independent confiscation review, and I understand the practice often is for the court to remand to the department to do that. So the issue would absolutely be raised. They have the right to raise a confiscation claim. It's a very difficult standard to the extent that the rate, the assessment is truly minimal. It's going to be almost impossible to make, but they do have the right to do it. That's why they're not focusing on the rate process. They want this per se possessory claim, just like a little bit of your real estate is taken. That's why they want to they get away from the difficult standard they have to face in the confiscation context or in the regulatory taking context.
Let me ask you the same question I asked your brother. If the legislature had passed a statute which said that the utilities here will get a fraction less than the reasonable rate of return, would that raise a taking issue?
Not at all, Your Honor. It would not. They could challenge it theoretically as a regulatory taking with a difficult multi-part standard they would not satisfy. And if it's small, I think they're out of the gate right there under the economic impact prong of the regulatory taking analysis, or simply on the confiscatory side of it, that when you look at the whole rate, a drop in the bucket is not going to do it.
But as that fraction grew, they would indeed have regulatory taking claim.
It would become a stronger one, but even there, it's not simply the investor's interest in the impact of the company, it's a balancing that the Supreme Court recognized. And this court, in some of its rate-related decisions in other industries, the insurance industry, Medicaid rates, has had rulings that very clearly don't say simply, if you any reasonable cost, you automatically have a right to pass on. They've allowed competitive adjustment factors. They've allowed caps on various capital cost components, various statutory or regulatory mechanisms that are precisely depart from.
But they're not totally regulated industries. That's the argument that your brother makes.
To my view, the regulated industries, all the more reason they should be subject. They have the benefit of a publicly sanctioned monopoly with all the economic benefits that entails. Investors go in there.
If they can't make a reasonable rate of return, you won't have a very healthy monopoly. So I'm just curious, where does this reasonable rate of return come from?
So the language, it's two things. It has been the department's practice for this industry to have the kind of individual cost review that's been the same. And it's certainly understandable why they want that to continue. Our position is they're not constitutionally entitled. The legislature is allowed to change its mind. And in other industries, the court has recognized a departure from that. That would be the Hingham Healthcare decision and the automobile insurers, where, again, other methodologies that aren't strictly based on individual cost recovery.
But where does reasonable rate of return come from? Is that language we've used in our...
It also is some early the 1970s decisions and the like. The courts that is in there. I would submit the court's more recent case, particularly in Hingham Healthcare, admittedly in another field, cuts the other way. The Supreme Court's language, which it has had since then in the Duquesne case and the Verizon case, where they talk about jeopardizing financial integrity, and also the courts high courts in 4 different states that identified my 16L letter, all depart sharply from that. So I admit it might almost say, in the Lingle case, the Supreme Court talked about a doctrine or certain phrasing sort of taking on a life of its own, not the same thing here, but maybe sort of what had happened there. So just to be clear, and we appreciate the court's time, we do not agree that there is an automatic right to pass on any and other reasonable cost, and that is constitutionally required.
Thank you,
Thank you, counsel.